how did the appellant receive the goods, Your
No,
Lordship?
but the existence of the goods is actually, is there any dispute with regard to the goods?
I am obliged, Your Lordship. Absolutely. May I request to turn the section 16? Because section
No, no,
16,
your presumption is that the goods might have been purchased from some other party, not this particular party.
Correct.
That is your case in short.
yes.
But
My-
are you in a position from whom they have purchased the goods? That's not on record.
Correct. That means, who has a burden to prove that? Whether, whether the, or I would put in this way, whether I discharge my burden as a revenue authority or not. What I have to do it? I can't prove negative things, Your Lordship. So what I have done it, as a officer, from whom he purchased the goods, I verified their records, because it is available in portal. In records, it shows that supplier did not have any inward EVA bill for last 3 months. That is one. So we went further. We examined their buyers because their invoices were available, but inward EVA bill was not, because Your Lordship, you are aware, without EVA bill, goods can't be moved. And it is the case of the outside state. I can understand if goods are in the state of Gujarat within 550 kilometers, they would have come with the submissions. Your Lordship, where is the question of requirement EVA bill, because the goods has been moved within the 50 kilometers. So I can understand. But there is a admitted facts that the supplier purchased these goods from outside state, and when there is an outside state, EVA bill is a mandatory. Now those EVA bills were not available. One. Two, those suppliers registration has been cancelled in 2021, and there is a period of 2024.
It is mandatory to supply, no?
Yes, Your Lordship.
But what about this fact?
This,
It is mandatory to supply. Supplier has committed some offense. But why he is
absolutely that. Why I am saying that, the question put before me was that, how did you discharge your burden? How did you say that goods were supplied by the supplier and invoice was of some other party? To that my answer is this, because I discharge my burden to show that goods did not supply by this supplier. Now when this raised this issue, what was the submission of the appellant? The submission of the appellant was that you raised this issue by making separate inquiry with the supplier and then I give answer. That is not the case, Your Lordship, because ultimately it is a case of the revenue, it is a revenue leakage, and law provides that. I can understand if section 130 specifically says that it is only obligation on the supplier then. But if Your Lordship just kindly again read, 130 says that, just Your Lordship for my understanding.
You are harping on the third issue, not first two issue. There is not much need.
Lordship, ultimately I have to prove that goods has been rightly confiscated, then whether I win on my best remedy is to fight on the third point, because that is absolutely covered within the four corner of the law. So if I don't want to go on the first and second point, because that is Your Lordship, I may not say that, but third, I am very serious on the third point, Your Lordship. So Your Lordship, as a lawyer, we always see the one hole in the entire dark room. So if I am in a position to enter through that hole, then why should I go into and look into other sides?
What about the third issue now? First two issue, there is not much need.
It is interesting that the allegation is not that my supplier's registration is cancelled. Allegation is that my supplier's registration is cancelled. When they ask me a query,
That for the last 3 months, they have not purchased anything.
my supplier, so my answer in a one line, if I can give to the department, I can show the registration certificate of my supplier. It is still active. He is a registered SSC with you. Go and first inquire with him. How do I know how he has done his business? He might have an explanation to give for not showing purchases for the last 3 months. He may have old stock with him.
Not made any inquiry with them.
Absolutely not. That was our reply to them. Please first inquire with them. They pass an order saying no, not needed. We feel that it is possible he may have supplied, procured from somewhere else, and therefore we confirm our show cause notice. We specifically, if my lord see our reply, we said first he is registered. You are not saying his registration is cancelled or that he is a bogus entity or anything. His registration is still active. his suppliers' registrations have been cancelled. First, please go to him. They may record his statement. If they believe that he states that no, this is all billing activity, etc., I am colluding with the supplier, all that needs to be on record. Just on the basis of a mere allegation, the order cannot be passed. I can understand the notice. They have passed an order merely on the basis of an allegation without absolutely any inquiry. So that is one point. Second point, my lords, I would want to point out, my learned friend says that this is unlike VAT, and this is a self-assessment regime. My lords, with my lords, utmost respect, that is not true. Even VAT was self-assessment regime, and there was possibility of assessment. Similarly, my lords, GST also is a self-assessment regime. Instead of assessment, now what the terminology used is adjudication. So it is as such not year-wise assessment, but they have the power to adjudicate under 73 as well as 74, where if it is found that my input tax credit, etc., is not admissible, they have to issue a notice under 73, 74, and thereafter they have to pass an order saying that you have been unable to justify your claim of input tax credit, and therefore you need to pay this amount. Here is a case where in fact that input tax credit would not even be claimed by me for all, if suppose I have purchased in this month, I would not even have claimed the input tax credit at this point of time. Where is the question of going, and secondly, as I said, this is a case where they are examining transaction of sale by me to my customer. Insofar as 130 is concerned, when it uses the phrase supplies or receives, that has to be read in juxtaposition to the point at which the goods have been intercepted. So suppose in this case, they go to my customer and say that, look, you are saying these goods are traveling from Ram Metals, but we feel no, these goods are traveling from somewhere else. Then that comes within the purview of section 130, that this transaction, if I am supplying with the intention to evade or someone else is receiving with the intent to evade, they can invoke 130. Here is a case where that transaction they are not picking. They are picking up my past transaction. So where is the question of going into that while initiating 130 proceedings for my sale transaction? And my lords, thirdly, my learned friend has not been able to answer on that non-obstant clause. According to me, it is going again to the root of the matter, because once 129 is a special provision which is my lords, fixed for these sorts of issues, and insofar as those 129 issues are concerned, my learned friend has no answer at all. Insofar as e-way bill, e-invoice, etc., those which were required to be examined by them, they have no answer. They are simply to justify their order, my lords, they are raising other issues which are not relevant to the issue in question, and therefore, my lords, our prayer is that this order needs to be set aside.
Lordship, before, no doubt, because in between, Lordship, you asked the query to him.
This last issue,
Lordship,
non-obstantly clause,
yes, that's the reason on 2 points, Your Lordship, because on respect of adjudication as well as 129 and 130, may I request to see the 129. What was the reason, and 129 and 130, and what was the reason to remove the word not with anything contained? May I request to see that compilation. And Lordship, first, if we read 129, that is on page number 1, and it's 129, it starts with notwithstanding, still it is, but in 130 it has been removed. 130 it has been removed. Now, if you see 130, if we read in 130, it does not say anything that if 129 started, then only 130 can be invoked. That is one. 2, it is an absolute stand-alone section. What is required to be seen, that whether the ingredients of section 130 has been complied with or not. If 130 has been complied with, then yes, my case raised there, and thereafter I have to just initiate all these proceedings. May I request to see one, Your Lordship, in that footnote 1, it says that notwithstanding, but now it says that where any person, where does it say that subject to section 129, something, there is no such word. If the intent of the government was that you start 129 and then 130, that is one, absolutely right. If there is a provision that yes, ultimately because in synergy, this is both are absolutely different, and that's the reason your lordship they remove the word notwithstanding, and they say that now let me keep. What is the purpose to keep that wording? Because I can understand.
No, but only question is what is envisaged under section 129, you can't incorporate here also in 130. That's no meaning.
There is a, so your lordship, as I said, this case is divided in two parts. That's the reason I started begin with that. Started with 129 because the both documents were in defect. Thereafter, initiated investigations. And your lordship, what the culled out from the investigation, only just I would like to read two paragraphs, because the transaction in dispute is transaction question itself is in dispute. And that's the reason we said that please give us clarification. If that person has given the clarification that yes, this is a purchase.
What about their main, have you sought any clarification from that person?
Lordship, my burden lies upon them. That's the reason I prove my burden. Thanks, oblige your lordship that.
Here you can't shift the burden is on you, because you say that no, your supplier is not genuine.
Yes.
That is your reason.
And what basis? There are documentary
So you
evidence.
have to discharge them
I
without making any inquiry.
made the inquiry.
What inquiry you have made?
Yes, through portal. There is no requirement to go physically there because my portal speaks about it. Because portal
But
itself
he
is a
may
law.
be having some other explanation for that.
That's the reason. There is no explanation for that. Kindly appreciate.
No, that supplier, if you have made any physical inquiry where that supplier.
Your lordship, that's
supplier.
kindly appreciate your lordship. Under GST law, there is no procedure like that as every transaction has to be examined. How the fake invoices documents and how fake invoices been found. In all these fake invoice cases, registration is valid. If you see your lordship, the suppliers, everything.
GST proceedings, actually there are many things.
Yes, your lordship. In techno, because it becomes
So
techno.
ultimately it has to be evolved by court of law, the proper procedure.
Yes. So portal, lordship, how the department discharges burden? Because once the department discharges burden, then it shifts upon them to prove that it is a valid transactions. And may I request to just I would like to read two paragraphs and then conclude my submissions, your lordship. Lordship, that paragraph, what I would like to.
Come with some.
It is the object being that the revenue generated from that compensation cess is given to the states who have lost revenue as a result of introduction of GST regime, because earlier the states which were dispatching the goods, they used to retain the VAT revenue, whereas GST is a destination based consumption tax. So the states which are more populated like Uttar Pradesh, etc., will gain more revenue, whereas Gujarat, which is an industrial state, may lose out on the revenue, and therefore to compensate this cess is introduced, and it is imposed only on the few commodities including motor vehicles. My lords, before 27th of July 2023, there was an explanation which Simpliciter gave 3-4 parameters to be fulfilled for me to be falling under the higher rate slab. One of the parameters which is in dispute presently is regarding ground clearance. Under the Motor Vehicles Act, I need a certificate from an authorized agency of the government showing what my ground clearance is. I had obtained that certificate whereby the ground clearance which was certified to me was lower than the ground clearance which was mentioned in the notification. So I did not apply the.
Certificate issued by authorized agency is binding on the GST.
It is not binding. I cannot say that it is binding, but because there was no other mechanism or no other definition, etc., available under the GST law, therefore we relied on the certification under the Motor Vehicles Act. It is not as if it was ever defined under the GST Act on what parameters this is to be calculated. Therefore, my lords, we relied on the Motor Vehicles Act certification, which is again not in dispute, facts are not in dispute, which said that the ground clearance is lower than the ground clearance which is prescribed under the GST. In fact, my lords, I am a distributor, so I am charging the cess which my manufacturer charges from me. So even the manufacturer of vehicles is considering this particular vehicle as having ground clearance below the specified limit, and therefore I charge that rate. That may not be absolutely relevant if he has erred I cannot say that he has erred, so please give me the benefit of that. That is not my case. More importantly, one of my competitors, Tata Motors, had maybe they may have anticipated this issue coming, that what can be the parameter for checking of ground clearance, whether it has to be computed in unladen form or laden form. Therefore, they specifically made an application for advance ruling before the Maharashtra authority, where this specific query was raised. Absolutely identical facts, where there also the same designated authority certified that the ground clearance is lower than the required ground clearance under the notification.
So far as this query is concerned, this issue is concerned, it is their case that no, that will apply only to that
That is,
particular
yes,
department.
that is their
And
case.
for that
To
purpose,
which
there is a section to that.
there is a section, I am obliged. So I'll come to that. So my contention is going to be that where advance ruling can be on number of aspects. I can file an advance ruling application solely regarding my product based on the composition, based on the ingredients used, etc., where the section would say that it binds only the applicant and the jurisdictional officer because it is your product which is in question. Here is a case where it is not as if there is any specification of product which is in question. It is a matter of legal interpretation. If it is a matter of legal interpretation, then the question would be that if my competitor has been enjoying the tax slab of 20%, can I be put to a higher tax slab? My lords may understand the scenario where I am charging at 22 and Tata Motors charging at 20, I'll be completely out of competition. So, my lords, while 103 may not bind the officer in that sense, like a judgment of, say, another high court or another tribunal, it will definitely have persuasive value on the officer. So, if that view is possible, then according to me, that view should be adopted to avoid discrimination also. Because this is a case, because in the case of Tata Motors or its distributors, the department will not be able to charge 22%. Because the order binds the department as well. So, my lords, consider a case where two vehicles in cutthroat competition, in today's day and age, even 1% of...
Constitutional validity of section 103, which one? That is challenged anywhere?
That is challenged before Honorable Gujarat High Court presently, my lords.
It is pending.
It is pending, my lords. So, that is challenged on this precise ground, that on these aspects of rate, whether the legislature can discriminate that even though your competitor is enjoying lower rate or exemption, you are put to pay tax at a higher rate. Where our alternative contention is that it may not be binding, strictly binding in that sense that suppose it is, as I said, very specific to facts, it may not bind others. But if in matters of legal interpretation, if an authority has given a ruling in some other case, then it should be followed. Malaj, I will also cite our High Court judgment where in the context of VAT Act, where I must show that under VAT Act there was no clear provision as to who it will bind. It was just a provision for determination. If my lords are aware that under VAT Act also, like advance ruling, there was a provision for determination. So, an applicant would go for determination order would be passed. It would necessarily bind the assessing officer of that applicant. Issue came up before the Honorable Gujarat High Court whether it binds in case of other assessees also. Honorable Gujarat High Court took a view that it will not bind the other assessees. So, other assessees cannot be precluded from litigating on the basis of determination of other assessee, but it will certainly bind the state. So, it is not open for the state to raise a contrary argument to a determination order if it is in favor of one
But
assessee.
even otherwise, there are so many cases we come across, actually, they are not consistent in their stand department. Wherever such orders suit them, they will follow that order.
I am obliged. So, that...
Yes, Mr. Moti, actually, no, on this issue, whether we are right or wrong.
May I just...
Let him complete, just by the way.
In fact, first I have placed on record this Maharashtra Advanced Ruling Appellate Authority, because it is not even that it is a one-page order. After elaborate discussion, the authority has come to the view that because under Motor Vehicle Act, needs to be measured, the ground clearance needs to be measured under laden condition. In the absence of any such specification under the GST law, that needs to be followed, and therefore that certificate needs to be given credence. In that context, if my lords may see page 18, para 15 onwards.
Yes,
May I just read some paragraphs? My lords, Justice Acharya has that.
page 18, sir.
To decide the aforementioned issue, we would like to discuss the meaning of the term ground clearance in relation to motor vehicle. However, it is observed that the term ground clearance is not defined anywhere in GST law, including GST Compensation to States Act 2017, which deals with the levy of compensation cess on motor vehicles at various prescribed rates on the goods specified under the schedule appended to cess rate notification number so and so. Therefore, under the above circumstances, by following the doctrine of legal construction, we will refer to the provisions of the Central Motor Vehicles Act 1988 and the rules made thereunder, which is in pari materia to the concerned act, that is GST Compensation to State Act, which deals with the impugned term ground clearance. Now we will refer to the concerned clause, that is section 56 of the Central Motor Vehicles Act 1988, which deals with the certificate of fitness of transport vehicles. For ease of reference, section 56 of Central Motor Vehicles Act 1988 is being reproduced herein under. Thus, I will skip the Millard's provision. Thus, the aforesaid provision mandates the manufacturer of motor vehicle to obtain certificate from the competent authority, which in the present case is the Automotive Research Association of India, to the effect that the vehicle manufactured by the manufacturer is complying with the Central Motor Vehicle rules. The said certificate issued by ARAI is based on the standards laid down in this regard. ARAI is a research institution of the automotive industry with the Ministry of Heavy Industries and Public Enterprise, Government of India. The ARAI has been certifying the specification dimension of vehicles including ground clearance in accordance with IS 9435. Further, it is seen that IS 9435 is Indian standard for terms and definitions relating to dimensions of road vehicles issued by Bureau of Indian Standards. Clause 5.8 of IS 9435, which deals with the minimum ground clearance of the motor vehicles, is being reproduced below. My lords may look at the technical definition. The distance between the ground and the lowest point of the center part of the vehicle. The center part is that part contained between two planes parallel to and equidistant from the longitude and median lane. That not relevant note may be seen. The measurement has to be done on fully laden vehicle to the maximum authorized GVW. So it is specifically said under Motor Vehicles Act that you need to measure ground clearance on fully laden basis. Thus, on perusal of the note part of the aforementioned clause, it is clearly revealed that the minimum ground clearance of any motor vehicles has to be measured only in fully laden state of that particular motor vehicle. There is no mention of unladen state anywhere in the said standard IS 9435 insofar as the measurement of ground clearance of motor vehicle is concerned. Thus, it can be decisively be inferred that as per standard set out under so and so issued by Bureau of Indian Standard, which is followed by the ARAI, the authorized body for certifying the fitness of motor vehicles, the ground clearance of the motor vehicles in their unladen state has no significance or implication. Accordingly, it is observed that any vehicles whose ground clearance in laden state are below 170 mm will not get covered under serial number 52B of the cess rate notification. That is the finding. And my lords, the High Court judgment which I was referring to is at serial number 2, page 23. This is in the context of VAT Act, where there was a determination order in the context of the Godrej Nupur Mehndi. In the case of, the determination was in the case of distributor. In the case of the manufacturer, that is Godrej, the assessing officers ought to take a different view. He wanted to say that the classification as given in the case of the determination of the distributor is not applicable to my case. In that context, if my lords may see page 26, class item 7. Yes, my lords. During the course of assessment, the petitioners relied on such determination order. The assessing officer, as noted, distinguished it by recording that the petitioner's product is used more as a hair dye or as a hair tonic, and whereas consideration before the commissioner of the product, it is stated to be used as mehndi on hands and feet. In our opinion, the assessing officer committed serious error in discarding the determination order passed by the commissioner. Section 80 of the VAT Act pertains to determination of disputed questions. Subsection 1 of section 80 authorizes the commissioner to pass an order determining the question inter alia as to whether any tax is payable in respect of any particular sale or purchase, or if tax is payable, the rate thereof. Once such a determination order is passed by the commissioner, it would bind the parties before the commissioner, which would include the assessee who might have urged the commissioner to make the determination, necessarily the department, unless of course either side has chosen to dispute such order in terms of appeal or revision provisions made under the Act. The courts have held that insofar as assessee is concerned, the said order can bind only the parties before the commissioner. In other words, in relation to same product, if some other dealer or manufacturer wishes to dispute the classification, the department cannot cite the determination order in case of some other assessee. However, unless the department has questioned the order of determination passed by the commissioner, it would bind the department in relation to other assessees also. So, and thereafter, my lords, Bombay High Court judgment as well as earlier Gujarat High Court judgment is followed, and the assessment order is set aside by the High Court as being contrary to determination order passed in another case. My lords,
Tata Motors case is challenged?
not challenged.
Not challenged, accepted by them.
They only say that because 103 says it only binds in that case, we will not follow it.
And in case of manufacturer, is there any determination order?
No, not in my case, not in my manufacturer's case. My lords, there one additional point for raising this demand is that on 27th of July 2023, there was a specific amendment made, fresh notification, whereby it was clarified under the GST law that you have to measure the my lords, ground clearance in unladen state. My lords, in my submission, this is something new which is being introduced. It was not as if it was inherently there and they want to just make it by way of a clarification. This point of ground clearance to be measured in unladen state, this is something new sought to be introduced. Therefore, post 27 July 2023, I will not be able to take this argument, because now there is a counter measure provided in the GST law, which is something different from the Motor Vehicle Act. So, I will have to go by whatever is specified under the GST law. But to say that that would also apply retrospectively, that, my lords, I would humbly submit that that should not be permissible. In that context, my lords, I have annexed a constitution bench judgment in the case of Vatika Township, where this entire, my lords, issue of retrospective operation of law has been clarified by the Honorable Supreme Court. I just read two paragraphs from that judgment. Page 49 may be seen of the compilation.
Yes.
Para 28.
General
Principle concerning retrospectivity. Para 28. Of the various rules guiding how a legislation has to be Of the various rules guiding how a legislation has to be interpreted, one established rule is that unless a contrary intention appears, a legislation is presumed not to be intended to have a retrospective operation. The idea behind the rule is that a current law should govern current activities. Law passed today cannot apply to the events of the past. If we do something today, we do it keeping in view the law of today and in force, and not tomorrow's backward adjustment of it. Our belief in the nature of the law is founded on the bedrock that every human being is entitled to arrange his affairs by relying on the existing law and should not find his plans have been retrospectively upset. This principle of law is known as les prospicit non respicit. Law looks forward, not backward. As was observed in Phillips versus Ayer, a retrospective legislation is contrary to the general principle that legislation by which the conduct of mankind is to be regulated when introduced for the first time to deal with future acts ought not to change the character of past transactions carried on upon the faith of the then existing law. The obvious basis of the principle against retrospectivity is the principle of fairness, which must be the basis of every legal rule, as was observed in so and so. Thus, legislations which modified accrued rights or which impose obligations or impose new duties or attach a new disability have to be treated as prospective unless the legislative intent is clearly to give the enactment a retrospective effect. Unless the legislation is for the purpose of supplying an obvious omission in a formal legislation or to explain a formal legislation. We need not note the cornucopia of case law available on the subject because aforesaid legal position clearly emerges from the various decisions, and this legal position was considered by the counsel for the parties. One more principle also mentioned in this judgment I would like to rely on. That is page 56. Para 41.2.
Yes.
At the same time, it is also mandated that there cannot be imposition of any tax without the authority of law. Such a law has to be unambiguous and should prescribe the liability to pay tax in clear terms. If the provision concerned of the taxing statute is ambiguous and vague and is susceptible to two interpretations, the interpretation which favors the subjects as against the revenue has to be preferred.
Well-known principle.
Yes, so if at all there were, because there may be two interpretations possible, that measurement in laden state or unladen state. If at all there were two interpretations, the one in my favor ought to have been accepted. More because the advance ruling authority in another case of a similar item had already opined that it has to be measured in laden state. So this principle applies with all the more force in my case. That would be my submission. And just one point, how they have dealt with this aspect of the notification being introduced. They say in the order that because even after the GST clarification, the Motor Vehicle Act rule continues to be the same, and therefore we will not accept this point that it is prospective. That is their argument for dealing with this aspect. I'll just point out that one paragraph from the order. If my lords may go to page 75. My lords have already noted that Tata Motors they have not followed because it is in another case that yes. They my lords observed in one paragraph. I am not troubling my lords with that. Page 75, para 30.10.
Yes.
One distinction they sought to make is between minimum ground clearance and ground clearance. They say that motor vehicles was minimum ground clearance. Here it is ground clearance, therefore different from motor vehicles. Like that is what they want to submit. And insofar as this aspect of the fresh notification, page 76, they reproduce this amendment and they say, I note, that an explanation to notification number so and so has been inserted with a notification number dated so and so explaining that the ground clearance is to be measured in unladen condition. I note that still ARAI measures minimum ground clearance in laden condition, whereas the CBIC has clarified that the ground clearance is to be measured in unladen condition. Thus, it is clear that the ground clearance is to be measured in unladen condition only. So they say under motor vehicle it still continues as laden and therefore it is to be measured as in unladen form only. Therefore, in my once this ARAI certificate etc. is not in doubt, once it is accepted that by way of ARAI certificate I qualify under the lower rate, then it is not open for them, particularly in view of the advanced ruling appellate authority, to take any other different view. In any case, at best, two interpretations are possible, where the interpretation in my favor should be accepted. And alternative contention, they have invoked section 74 in the present case of evasion. Where is the question of evasion? I am
Question of levying penalty.
Yes, so penalty, evasion, larger period of limitation, everything they have invoked, where Maharaj, I have just produced a judgment of Honorable Apex Court, where they have said that there needs to be a positive finding of fraud for invoking larger. That is absolutely absent in this case, and therefore this order cannot be Maharaj, sir.
Yes, so as
Obliged.
compared to earlier case, this is somewhat weak case for you. Yes.
So as an officer,
Officer can take such a
Absolute-
view actually when advanced ruling authority has given such finding that that is not, of course, action is there, but ultimately you have to.
they, what it appears, it appears that what has gone to mind of this officer, that may I request for that purpose, Your Lordship, see the notification, which is under the dispute, and the notification is on page number 8 of the 8 of this impugn order, where they provided the 3 criteria, that yes, any motor vehicle, that includes the utility vehicle having more than 1500 cc. Second criteria is regarding the length, and third criteria, which is under dispute, regarding the ground clearance. This is the ground clearance should be above 170 mm. Now, law has not provided that what is meaning of how it has to be measured. So it appears that, Your Lordship, because of the representation has been made, and the legislature realizes that this point has not been mentioned, but what is actually our intention from day one. They says that my intention from day one was the unladen condition, and therefore how the amendment has been introduced, that is most important. They have come with the amendment with the explanations, and they have filled the gap.
You ought to have challenged that order. You are not challenged, you have accepted.
Yes, Your Lordship. So that is
So
the reason
on
that,
that point first, we'll interpret the notification subsequently.
okay, I'll in respect of section 103, and
By any way of acceleration or
it has been clarified. I may say it has been clarified, not even,
entry is amended.
yes. So,
No.
so, Your Lordship, in respect of my answer to my lords regarding that why that order was not challenged.
Yes.
Your Lordship, ultimately law has been clarified. What honorable member says, that based on that, since the law has been clarified, there is no requirement to be challenged. That point one. Specifically in a case when section 103 says
That
that,
was not under the amended entry.
no, they have seen but that decision specifically dealt with the amended entry also. They have referred to that
No,
amended
they
entry.
refer to that's all right, but ultimately actually case arose while considering the earlier entry.
Yes, Your Lordship. But since ultimately in my jurisdiction, when I realizes that this is something wrong, and this case even dispute started much before that, even the clarification came, Your Lordship. So, no doubt, it is an admitted fact that that order has not been challenged. I can't run away from that
What
fact.
is the stand of the department on this issue? Whether any such order is passed by the advanced ruling authority, whether it is binding on the department or not?
Your Lordship, our stand is very clear.
If the facts are similar, there is no distinguishing
Yes, Your
feature.
Lordship. That is the
And in
reason
that case,
our stand is very clear, because legislature support us on that aspect, and therefore we can't go beyond the legislature. Section 103 says that it is applicable to the assessee and that officer only.
is
Not
it
to,
not amounting to the discrimination violative of Article 14 of the Constitution?
Your Lordship, it is in both ways. Suppose it goes against them also, then they says it is not applicable to me. Today it is in favor.
No, even
Therefore
our-
they say that it
even
is my, it is applicable to me.
Gujarat High Court has also made it very clear. It is open for the subject to accept or not to accept. But so far as the department is concerned, it is binding.
So, Your Lordship, in that case, because department case,
Now that
I'm bound by the judicial
High Court
decision.
says- High Court
High Court, I
judgment-
can't run away from the High Court. I can't go beyond
But
the,
that judgment has been challenged by you.
No, that is-
By the income tax department.
by income tax. It is also
authority.
it is not also challenged. But
then
there also
everything
is
is
section
accepted
80.
and still you are taking this view in this matter.
Yes. So section 80 in that case, it is absolutely silent. And in that context, because there was no specific provision, so Honorable Court did not come with that point whether how the section like in this case 103 is there. There was no express provision there, and therefore the Honorable High Court exercised that jurisdiction under Article 226 and had taken the view. Today also we are sitting in the appeal provisions. We are bound by the absolutely legal provisions. Even GlaxoSmithKline recently in Supreme Court, they say that if law prescribes that yes, the delay cannot be delay cannot be condoned beyond the 30 days or beyond the prescribed limit, no any authority has a power to go beyond it. So my respectful submission is today is that we are today in the statutory provisions. It is an appellate provision. In appellate provision, whether can we see that 103 provision or not? According my respectful submission is that 103 is applicable only to the assessee and the proper officer, and therefore it is not binding on me, Your Lordship, in respect of deciding this issue. That is one, and therefore I held as per the notifications applicable. Now second question come, Your Lordship, whether this notification has to be considered as a clarificatory in nature or whether it is applicable prospectively, because my submission of my learned friend is that ultimately it is a prospectively applicable, not retrospectively applicable. Now for that purpose, what we require to see is the intention of the government and two, wording of the statute, wording of the notification, and therefore may I request to see the wording of the notification. Just is a two line only. Page number that notification is on page number 119. Just preamble of the notification.
Yes.
119, it says that in exercise of the power conferred by subsection 2 of section 8 of the Goods and Service Tax Compensation to State Act 2017, the central government on the recommendation of the council hereby makes the following further amendments in the notification of the Government of India in the Ministry of Finance, that means Department of Revenue number 1 of 2017. Compensation stage rate dated 28 June 2017, published in the official gazette. And Your Lordship, that
And we are
relevant,
concerned with this.
yes, we
only.
are concerned with this absolutely paragraph number, page number 124 and Roman 14, Your Lordship.
Yes.
Against the serial number 52B in column 3, for the entry motor vehicle known as a utility vehicle by whatever name called, including sports utility vehicle, multi utility vehicles, multi-purpose vehicles, or cross over the utility vehicles with engine capacity exceeding 1500 cc, length exceeding 4000 mm, and the ground clearance 170 mm and above. Explanation: for the purpose of this entry, the ground clearance means the ground clearance in the unladen condition shall be substituted. Now, what is the interpretation of substitute? The Honorable Supreme Court, in the case of Indian Tobacco, just I also hand over. In that case, they say what is the meaning of substitute? Substitute means that it is replacing. The law was always there from day one, but by way of putting the substitute, that means it is existence from day of that birth. That is the meaning of that. That is the meaning interpretation given by the Honorable Supreme Court in the case of Indian Tobacco in the context of the customs matter. May I just tender the copy of that decision? That Indian Tobacco decision, that is on page number 14, and just I read paragraph 3 on page number 15. It says that the respondent herein is Association of Cultivated Tobacco, an incentive scheme was introduced by the Government of India in 1970s regarding the export and import policy of duty entitlement passbook, whereby whether 2% incentive was provided out of the export carried from the notified container depots. Ganthur was not mentioned in the notification 7 April 97 issued pursuant to or in furtherance of the policy decision which came into force from the 14. In terms of the notification, exemption was granted from payment of additional duty. Section 3 of the custom tariff act to those which have been issued a duty entitlement passbook and thereafter. Now para 4. Undisputedly, upon representation made by the respondent association, amendment to the notification was made on or about 27 November 97. The relevant portion as under the word Tuticorin and Visakhapatnam, the words Tuticorin, Visakhapatnam, Kakinada shall be substituted, and the words again in second also lastly it says is a substituted. Now, may you all see on page number 16, para 15, it says that the word substitute ordinary would mean to put in a place of another or to replace. In Blackstock Dictionary, 5th edition, at page number 1281, the word substitute has been defined to mean to put in the place of another person or thing or to exchange. In Collins English Dictionary, the word substitute has been defined to mean to serve or cause to serve in place of another person or thing to replace. Replace with, or person or thing that serves in place of another, such as a player in a game who takes the place of an injured colleague. By reason of the aforementioned amendment, no substantive right has been taken away, no penal consequence has been imposed. Only obvious mistake has sought to be removed thereby. There cannot be further to be doubt whatever when a person is held to be eligible to obtain the benefit of an exemption, the same should be liberally construed. And thereafter, on para 22, it says that had the interest of the government been only to extend the benefit only to the exporters from any other seaport, airport or container, rescue to the proviso appended to subclause 2 of notification could have been taken. By reason of the notification dated 1 seaport and 6 inland container depot has been added. The last word in the category of seaport, namely Tuticorin Visakhapatnam, has been substituted by the words Tuticorin Visakhapatnam. Similarly, 2 words has been substituted. So, what the meaning has been taken? That substituted, that is in place. Now, in present case, meaning definition was not given. The intents of the government was to always it is unleaded, and therefore the government has clarified that situation that now
But if that intention was very much right from the beginning, then the clarification which is made by subsequent notification should have been there right from that day.
absolutely. So that's
Why
the
it
reason.
was not there?
Yes, that is the reason it has been missed out by the government to define that, and therefore the government says that we
No.
substitute the
Because
word.
of your mistake, you are penalizing the litigant.
Yes. So in that situation also larger period cannot be invoked. But larger period cannot be invoked. But if the demand can be made within the normal period of time. Today, Lordship, the dispute is from the period of September 2017.
July 23 onwards, you can do it.
But
Nobody would prevent you from
I,
doing that. And even they are also not disputing.
Yes, absolutely, Lordship. But the question is that the dispute period is September 2017 to August 2020. Now, if law permits me to recover the amount within the normal period of time, where even there is no fraud collusion, then I can recover
Law
that.
permits you to recover provided they are liable to pay.
Yes. So my that is my respectful submission is regarding substitute. It has to be word in the case of the it has to be word it was in existence from day one, Your Lordship. Secondly, Your Lordship, in the case of the income tax decision, a similar thing happened. In case of in the case of Your Lordship, in the one more case, Your Lordship, just then I go on WPIL Limited. It is in the case of the exemption under the excise. What was the case that power driven pumps and parts were exempted from 1989. In 94 they amended the entry and they had given extension only to the power driven pump only and not the parts. Later on again notification was introduced and they again clarified the situation by a substitution. The Honorable Supreme Court says that ultimately this entry has to be read that from day one, because the word substitute has been used, and that is also my sum and substance argument in respect of this matter. I can't stretch beyond it because my legal point submission is that one, the word substitute has been used and therefore it is a intent of the government to carry out or to correct their mistakes. That is one. Now, Lordship has rightly put the question, does it mean that the associate should be penalized? Associate should not be penalized. But if the demand can be made within the time limit, then they should not shirk away from the responsibility also. That is why one submission. And second, in respect of section 103, it is by, in case of Tata Motor, which is definitely against the department, in that case it is applicable to them only, it is not applicable to others. Otherwise, Your Lordship, nobody has stopped them to approach before the advance ruling authority. They would have gone there. And the legislature clear intention. And when there is an intent of the legislature that the benefit is given to that assessee and the assessing officer, not beyond it, then Your Lordship, it is binding to them. That is my respectful submission.
Yes.
Just
Yeah, what about the substitution?
Miller's para 16 may be seen.
Para?
16, page 16. The judgment relied upon my learned friend.
Para 16. Page 16, yes.
By reason of the aforementioned amendment, no substantive right has been taken away, nor any penal consequence has been imposed. Only an obvious mistake was sought to be removed. So the test laid down is it was an obvious omission, and if it is inserted, then yes, there are other judgments also saying that then it should be read retrospectively. This was not an obvious omission. There was how the laden condition is to be measured was not mentioned, and the authority had interpreted that therefore the Central Motor Vehicle Act test should be applied. So this is not a case of any obvious omission, and admittedly they have not challenged that order. So for this period, this entire period up to 27th of July 23, Tata Motors cannot be asked to pay the differential amount of cess. So once it is accepted that that order was not challenged, secondly, two interpretations were possible. It is not a case where it was very, very clear and only for further clarification this is to be done. In such a circumstance, this principle cannot apply. This principle of substitution retrospective amendment can apply only because if my lords may see the facts, one inland container depot was missed out from the notification, although it was an inland container depot, and therefore substituted and given retrospective effect. This is not a case where the rate of tax was being increased. So the judgment has to...
So in all cases, such actual interpretations should not be applied.
Cannot be applied. It has to be limited to the facts. And just one more aspect I may point out. In fact, in the Act, insofar as exemptions are concerned, the section says that if at all an amendment is made in an exemption notification, it has to be made within a year. Only then it will date back to the issuance of the notification. If my lords may see section 11 subsection 3 of the CGST Act may not be directly relevant, but that shows that the legislature also intended that they don't want to give retrospectivity for 6 years, 7 years, unlimited period of time. If at all they want to insert a clarification, that has to be done within a period of 1 year, and they may expressly say that it applies from the date of the notice. Here, if my lords may have observed in the notification, it expressly says that it will come into effect from 27th of July 2023. So it is not even as if suppose they had introduced it retrospectively, I would have to challenge the amendment in a writ petition. Here they have themselves said that it will prospectively apply, and once it is amending the provision as my lords had pointed out, then there is no question of it being given retrospective effect, particularly because of the advance ruling authority. Otherwise it could have been a different issue if suppose this was not there. So my submission again, they also admitted, my lords, that Godrej judgment is not challenged. So merely because it is in writ petition, that does not mean it stops, the principle stops being binding, my lords, on the honorable tribunal. And therefore, my lords, my submission is that the appeal to this.
So appeal is allowed.
Government side मजबूत है.
Yes, Your Lordship, that department has to learn lot.
Break वगैरह.
May I mention?
Yes.
In fact, these two matters were assigned to my colleague Mr. Patel, and because of certain medical emergency, he is on leave today. And only yesterday night, these two matters are allotted to me. Now, neither I have seen the matter nor we don't have any case record. So may I request for adjourn the matter?
Let us read together. Actually,
But it will be very difficult for us because we have scarcity of the staff also, no recruitments are there,
That will
no
always
case paper,
remain.
no record is there.
That will always
So
remain.
that is the problem, if your honor can grant me the adjournment.
the government should have come out from this actually practice now. Every time, as and when matter is called out, somebody asks for time on behalf of the government.
Yes, how, but
Recently, you might have read in the newspaper, Chief Justice of present Gujarat High Court actually have scolded in so many words.
yes,
And they have called for all top officers of the government that affidavits prepared in a such laconic way. So teach them something to make proper
that is
representation
why,
and
that is why now the provision is there to grant only three adjournment in the GST. And this being the first adjournment, so I request your lordship to grant me the adjournment.
no. Looking to Mr. Baris, we don't grant any adjournment. He is capable enough to prepare even at the last moment.
Lordship.
Case number 3.
Lordship, one more aspect, sorry. In fact, no wakalatnama is annexed with the paper book.
It is
So
there with
whether
the
my
registry.
learned friend,
It is there with the
is
registry.
appearing as a charter accountant or as an advocate, because we have a different provision for appearance. So Ari is appearing as an advocate or a charter accountant?
Appearing as an advocate, and
Okay,
my
so
wakalatnama wakalatnama is there with the registry. It is not to be provided to the government.
No, but in the paper book, that copy is required
No,
to be
no,
annexed,
not
so we can
necessary.
come to know. Lordship, it
Wakalatnama
can
is
give
not to
us,
be
it
provided.
can give us some idea that we have to argue before the charter accountant or the lawyer, so we can also prepare ourselves in that manner, Your Honor.
Now he is sitting in the chair of a registrar. Let the
That-
registry
that-
take care.
That wakalatnama is not there, Your
Let
Honor.
the
So
registry.
you are a mighty government, you pass a legislature in the legislative assembly or parliament, that every matter which should be filed before the court of law and wakalatnama should always be there and copy to the other side should
Copy to
also
the
be
other
given
side.
along with
Because in
wakalatnama.
index it is written wakalatnama, Your Honor. Your Honors can see the index, Your Honors. And there is no pagination is there, no page number is given.
Bound to be, because actually,
કોપી એમને આપી દેજો ને કોપી એમને આપજો
Let him have the first word. Thereafter, he will be on the back foot. This is second appeal under section 112 of the GST Acts.
yes,
Essentially, the challenge is to the cancellation of my registration. A drastic step of cancelling my registration. So cause notice only one line. Final order 3-4 lines. Drastic step of cancelling my GST registration has been taken up by the department. But bare minimum facts I may point out. Please have a look at page 29.
so cause notice.
So cause notice for cancellation of registration. This is in the prescribed format.
Registration.
The only reason, I may just point out, whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reasons. 1. Registration has been obtained by means of fraud, willful misstatement or suppression of facts. Again, same observation. Registration has been obtained by means of fraud, willful misstatement or suppression of facts. You are hereby directed to furnish a reply within 30 days. You are directed to appear before undersigned on so and so day. So only a one line so cause. Cryptic, vague, cyclocyclic.
So there is no clarity as
No
to
clarity.
what fraud you
What
have committed.
fraud I have committed.
What misstatement you have made.
Whether there is fraud, whether there is willful misstatement, whether it is suppression, nothing is stated. Now please have a look at the order, page 27.
And they are expecting your reply on this so cause notice.
They're expecting me to file a detailed reply and even appear before the authority.
So you have to assume the fraud, you have to assume the misrepresentation, and you have to assume the suppression
Suppression.
of facts.
And now the order which is at page number 27, it's altogether on different ground. I may read. Order for cancellation of registration. Please mark the effective date of cancellation of your registration is 17th September 2020. Page 27, if I'm.
Yes, yes.
The order is dated 2nd December 2021. On the top, right hand side. Order is dated 2nd December 2021, but the effective date of cancellation is 17th September 2020. So retrospective cancellation of registration.
So there is no so cause notice to that effect? that
Yes.
Why your registration should not be cancelled
First-
retrospectively?
Yes, so cause is only qua why your registration should not be cancelled. No so cause qua why